during the course of a day at WVAR, we get so many questions about the law and about ethics and disclosure law and earnest money that we thought that this edition of WVAR Briefing would it would be helpful to devote it to sit down with none other than WVAR legal counsel and the voice of the legal hotline, Brad Sorrels, to talk about a few of these issues. Okay. Well, let's move on to let's change subjects a little bit and go to earnest money, earnest money deposits.
Sure.
We get a lot of that. It's such, and you may get those calls too. It's such a simple thing that causes so much controversy, and so you and I have had this piece of the discussion before. So let's say first off, earnest money is not required for a real estate transaction. Is that correct? By law?
No, there's no law that requires earnest money. Earnest money is really kind of a convention that came from England. I mean, it was literally to show that the buyer was in earnest.
Back then, it probably could have been goats or bags of gold or anything.
You know, whatever. But I mean, it was really just to show that the buyer was sincere and wasn't just talking. But there's no requirement for it. Oh, you'll hear a lot of people take the position that, well, you have to have earnest money because that's the consideration for the contract. And it is true that all contracts have to be supported by consideration. If you don't have consideration, you don't have a contract. You have perhaps a gratuitous promise. But what the consideration in an agreement to sell and buy property, the consideration flows from both parties. The buyer is making a promise to pay the purchase price, and the seller is making a promise to convey free and clear title. And that's the consideration that supports that contract. Earnest money's a convention. It's almost like a habit, but it's not necessary to have a valid contract.
And we can't, we've tried to do research. We've talked with the National Association. There are some people that just, this is it. You can't have it. They'll walk away. They won't do this. Without earnest money, you got to do it. But we can't find any quantitative research that shows that deals fall through more often with earnest money and without. We don't think that number's out there. Deals fall through or they don't fall through. And frankly, it's always been our contention that nobody's going to write a check for more earnest money than they're willing to walk away from. Or in most cases, they won't. And that could
Usually, yeah.
I mean, that could be $100,000 if I'm buying a $2 million house. But it's that same concept. So another quick question on it. If I collect earnest money, who's responsible for depositing it, and how long do they have to deposit it? Do you have a
if it's the agent that gets it, an agent needs to promptly, and that really means as soon as possible, get it to the broker, and then the broker needs to deposit it in their trust account immediately.
Even if they don't have a ratified contract, or?
Yeah, I mean, there's no requirement in the code to wait for a fully executed contract.
So what if would it stand in to say if I put in my purchase agreement that any earnest money will be deposited as soon as the contract is ratified? Is that okay then if you do it that way? And the reason I ask is because a lot of brokers don't want to put that money in the bank until they have a ratified contract because they don't want to have to cut another check. And I mean,
I understand that, and it makes good business sense, and I can see why they say that, but that's not what the West Virginia Code says.
But even if you have that language in your contract, does that give you a pass, so to speak?
No, you cannot contract your way around the code.
Okay.
I mean, that's an obligation that is put on licensees, and you can't agree with a non-licensee that you're not going to abide by the standards imposed on licensees by law.
Kind of the old you only have to obey the lawful instructions of your seller, not
sure.
So let's talk about the other horrible part of earnest money, and that's when the deal does fall through.
Yeah, and that's when I hear about it.
Well, that's when we all hear about it.
Yeah.
Nobody ever calls us and says, "Hey, what a great deal I just had." So it falls through. It's always been my understanding that it can't be a real estate broker, no matter how obvious it might be, that determines if a contract's been breached, and that's why they can't return the earnest money. So if that's the case, then what the Real Estate Commission did a long time ago was say you have to have this mutual consent form, mutual release form that both parties agree to where the earnest money is going to go. And that's the way they handle it. Otherwise, you go to magistrate court or whatever. But the new wave of things is people are actually, or brokers and boards are actually putting in their contract, if the earnest money, if the deal falls through and the earnest money issue isn't resolved within 1 year,
Right.
then at the end of that year, the money goes to whatever it says.
Yeah, so something like, I think the Canal Valley form says that if the matter doesn't go to closing after 1 year, the earnest money will be returned to the buyer unless prior to the expiration of that 1 year, the broker is provided with reasonable evidence that the matter is in litigation.
Okay, so unless it goes to court.
And what the brokers got tired of was, this deal falls apart on the house, and here's $100, $200, $300 worth of earnest money sitting in their account. Nobody will sign a mutual release, and now it's 5 years later. The seller sold his house to somebody else. The buyer's moved out of town, but still the broker's got this money in the trust account. What's supposed to happen to it? And for a while there was people were giving it to the state auditor's office as unclaimed property. But really, in that case, there was a requirement in there where it had to be in dispute who it went to, or something like that. But
well, at one point, I think you devised a form when they had to send it to the treasurer's office, because otherwise it would be most unclaimed checks are a dividend check or a stock check that's got somebody's name on it. But in this case, because it's the earnest money, it would be in the broker's trust account, who would then have to write a check, and so it really wouldn't be clear.
Yeah, well, I think what the problem was, it wasn't that it was unclaimed property. It was property of which the owner was unknown, and there was a problem with getting it to fit into a clear pigeonhole for the auditor's office to take it. And so they came up with this. A lot of boards came up with that different solution of turn it over within 1 year, unless there's litigation. I think that's fine because it's part of the contract. Both parties have agreed to it in writing, and it's a separate clause. Here's what's going to happen, and they've agreed to that, which is what the Real Estate Commission has indicated they want, although that's not in a specific regulation. They were regulation poor when it comes to earnest money, right, other than depositing it. But I mean, if it were up to me, I think I'd get rid of earnest money.
Well, I'm with you on there, but that puts anybody that just listened, you stroked out about half the membership.
Well, I mean, what takes the place of something to show that you're earnest these days is your various types of letters you get from a bank, a pre-approval letter, a commitment letter. They've got half a dozen different letters they give out, but those are what the buyer brings to the table these days that says, I'm bona fide and I really can buy this house.
What would you say would it be, in your opinion, a violation of the law if I, as a broker, refused to submit an offer to someone per se because they didn't have earnest money, and my seller said they want $500 worth of earnest money, and so another agent brings me an offer that doesn't have earnest money, and I don't present it and say, you've got to take this back and put earnest money with it. There's no earnest money.
But I think it would be. I mean, if you look at what the law says, one of the duties imposed on licensees is, and I forget the exact wording, but it's promptly tendered to their principal all written offers received. It doesn't say written offers accompanied by earnest money.
So if I present an offer, then the answer from the listing agent shouldn't be, where's the earnest money? It should be, thank you.
Well, I mean, if they want earnest money, they could say, where is it? And if the buyer says, I don't believe in earnest money, that's my offer, then it's thank you.
Okay. So it's okay to ask the questions on
sure.
To slow down the presentation.
I don't think it's a valid basis to ignore that mandate of the law that says tender all written offers to your principal promptly.
What if, for example, and this will be a breach of contract issue, say that I'm the buyer, and I say I'm going to put down X number of dollars earnest money, and I never do, and the deal goes through, and at the end of the deal, when it's almost ready to close, the seller says, "Wait a minute, we're in breach here because he never gave me the earnest money he said he was going to give me. I'm out." Is that legitimate?
No, I would say no. I mean, of course, every situation is going to depend on the facts, but I mean, you got a bunch of things there. I mean, you said the deal's going through. I mean, everybody's progressed. And
well, I guess my question is, can they just use that simple fact as a way out?
Yeah, I would say no to that.
Okay.
For the reason that
so earnest money really doesn't even hold them to the deal like we think it does. It's not that big of a deal, I guess.
Well, it's typically earnest money is not going to be a material part of the consideration. It's just, I mean, the consideration to be paid is the $100,000 purchase price, and for the buyer to say, well, it's been breached because I didn't get, the seller to say it's been breached because I didn't get $100.
Mm-hmm.
I mean, that's not a substantial breach. And the other part in the scenario you set up is that the seller had proceeded with the contract. So even under the tenuous argument that it was a breach, that breach has been waived. So, I mean, you can't move forward and then at the last minute say, I want to do something different. Hey, you missed that step back there 10 steps ago, so the whole deal's off.
And then I guess conversely, the same would apply to the buyer. Who'd say, sorry, I'm walking out because I never gave you the earnest money like I said it was going to.
Yeah, well, that one's even more clear because you can't count on your own breach or your own failure to perform as the basis for terminating a contract. It's just like if the contract says, closing shall be on June 1st and time is of the essence. Well, if you're the buyer sitting at the closing table and the seller doesn't show up, well, then you can terminate the contract because the seller failed to perform. But I can't skip the closing and say, well, it didn't happen on the 1st, therefore I'm terminating the contract. The right to terminate because something didn't happen when required falls to the other party, not the party that didn't perform.
So I can't create my own failure just because I went out of the contract.
Correct.
That's it. And does that apply to? It's a little step away from earnest money, but what about all those things? I didn't get the home inspection when I said I was going to, or I didn't do this, or I didn't do that. Are all those things kind of immaterial to the process, and I just kind of missed my opportunity, and I can't get out of it because I didn't have one? If I failed to get it, are they all? I mean, it's not just earnest money, but they kind of across the board. I didn't get a pest inspection, and now I'm worried about termites, and the seller says, "Too bad, you had your chance and you didn't do it."
Yeah, I mean, I think those are all the type of thing that you may need to do them within a certain time, or you've waived the opportunity to do them.
But I haven't waived my right to continue buying the house. I just waived my right
Correct.
not to have that inspection or rely on that
Correct.
inspection. So to do that makes sense. So what would you say to the broker of a company who says to their agents, we're not going to take any listings without earnest money? Would that be a violation of law or just questionable business? If I'm not going to take your listing unless you tell the seller that they have to have earnest money, that they have to require earnest money, I guess would be the.
Well, I don't know that it'd be a violation of the law, but I mean you're really getting into the seller's business too
Right.
much.
Well, we've had cases where companies have said we have a company policy where each one of our deals is going to require $1,000 earnest money, and to me, that's just what you said. I mean, the company can't make those kind of requirements on buyers and sellers. That's up to
Yeah,
them.
I mean, you need to be a little bit careful when you start inserting yourself into the transaction. The more you insert yourself into the transaction and take control over it and become a real player as opposed to assisting the real player, you're setting yourself up for liability.
That's what I always say in Ray's rule of real estate is the realtor's in charge of the process, not the decision.
Correct.
And that's the kind of things we often unintentionally, but they forget. Why would you want to do that? Why would you want to do this? You should do that. And that's where they're trying to help, but they sort of insert themselves in
Sure.
the process at that time. So earnest money, I mean, bottom line, it's not required by law.
Right.
We have no evidence that it either helps or doesn't help the transaction or keeps everybody's feet to the fire, so to speak. It may not, but we have no evidence that it does or it doesn't. And it's not, as you said, a material breach. So the lack of it, while I will tell you that if you say in the contract that you've collected X number of dollars earnest money and you never collected and you never put an addendum in that contract and the deal is fine or whatever, that still doesn't mean it's not a violation of real estate law in the sense that you have a piece of paper that says you have $500 you never collected. And so it doesn't show up in your trust account. And so if down the road, I think the advice I would say or get your thoughts on is if both parties agree, no big deal, we're going to proceed forward, don't worry about that earnest money, then there needs to be some sort of addendum in writing so that the real estate commission knows that there's no earnest money.
When they do audits, they come in and they check paperwork. And the paperwork needs to align with, for example, bank accounts. And it's, okay, it says right there, $500 came in. Where's the $500? And there's just no need to set up something that looks bad when what it really was carelessness.
Right.
Go ahead and cross that T and you won't have to worry about it anymore.
What are your other thoughts on earnest money? Anything else? I mean, I like your idea of, I agree, I don't use it.
Yeah, I just see it cause so much trouble. And it's amazing how people, how aggressive or defensive they will get about a $500 earnest money check when in the midst of a $300,000 transaction, and people get mad about it and they want to fight, and I don't want to give that up, and he should have bought. And what you said before, the broker can't decide these things. Not only is the broker not really legally qualified to make that determination, that's not part of the contract between the seller and the broker.
Right.
It's getting perilously close to practicing law without a license. And probably most important for your average broker's point of view is if they did start getting into the habit of making that decision, what they're doing is they're putting a target on their back, because you're already starting out with people that don't agree. And they're not going to suddenly agree with your decision when it goes against them. And whoever you decide against is likely to sue about it, and you'd be the prime candidate because you're the one that said where the money went. And so what I routinely tell people is that needs to be decided by a court of competent jurisdiction. And for most, your average residential earnest money deposit, a court of competent jurisdiction is going to be the magistrate court.
If you could put you on the spot, if you could tell our membership or give them one piece of advice to help keep them out of trouble, what would it be?
About earnest money? Or
just anything in real estate in general? We'll insert some Jeopardy ticks here.
I need the music. I don't know. I guess, you need to be diligent. You need to, keep an accurate paper trail. It's real easy to remember what was said yesterday, but if something comes up 6 months down the road, your memory's not going to be adequate to what happened at that meeting. I think having your file properly annotated, keep notes of things that go on, and be careful in your representations. And I don't know, I guess maybe one thing, I'm trying to think about the calls that I get in the cases I've been involved in, is stick to your job. Your job is to take a property to closing. So if you stick to that job and let other people do their jobs, that really limits your liability, because liability often flows when you're getting out on a limb that you don't have any place being there in the first place.
Great. Thank you very much, Brad.
Thank you.
This concludes part 2 of our discussions with WVAR General Counsel Brad Sorrels, topic being earnest money. We hope that we've cleared up some misconceptions and helped people struggle through this very often controversial issue. Until next time, again, thanks for listening.